Today, University of California, Berkeley Dean School of Law, Erwin Chemerinsky, is going to talk about his book, No Democracy Lasts Forever, where he contends that our Constitution includes inherent flaws that are threats to the United States democracy. Much might be fixed by the Congress or the Supreme Court, but polarization stands in the way. One might logically conclude that by amending the Constitution, we could solve the problem, yet logic seldom does have precedent, given that only 15 of the 11,848 amendments proposed since 1789 have passed. Actually, I don't think that 15 is the right number. I think we're at, because the 20th amendment, I think we've done more amendments than that. Sorry about the data not being correct in front of me. Chemerinsky, in his book, contends that without major changes, the Constitution is beyond redemption, and that it has created a government that can no longer deal with our urgent issues. So we're interested in his perspective as he looks at that, because what he is talking about is what would happen if there were a new constitutional convention as we come to our 250th year, where we recognize and honor the values of our country, where we recognize and honor the founders of our country who set forth the idea of a more perfect union. That doesn't mean that we are not critical of the country we love. And so we offer the distinguished scholar to talk about no democracy lasts forever. And perhaps he would argue that we should rewrite the Constitution start to finish, not a small task. Dr. Chemerinsky, tell us your story.
Thank you so much for inviting me to speak. I'm honored, and thank you for the kind introduction. The book, No Democracy Lasts Forever, How the Constitution Threatens the United States, was completed in September of 2023. It's then that I chose the title. And so it's not a reaction to the November 2024 election or anything that's happened since January 20th. The thesis of the book is that there is a crisis facing American democracy. To a large extent, the crisis stems from choices that were made in drafting the Constitution in 1787. But because of recent developments, these problems have become much more salient and urgent, and that everything that's wrong can be fixed. Some can be fixed by statute. Some might take a constitutional amendment. And for the longer term, there's going to be a point at which we do draft a new constitution. But I also think it's important to consider what will happen if nothing changes. So I'd like now to talk about a few things. I want to talk about, first, what is the crisis facing American democracy? Second, how did the Constitution contribute to this? Third, how can we fix it? And fourth, how do the events since January 20th relate to how the Constitution is flawed and how our democracy is in danger? So why did I write the book? Why do I believe there's a crisis facing American democracy? There's no doubt that our government has lost the faith of the people. Every year, the Pew Research Institute does a survey of public confidence in the federal government. They started this in the 1950s. The high watermark was in 1964. 77% of the people expressed confidence in the government. Last year, when this was done, it was at 20%. Likewise, confidence in the branches of the government are at a low. The last survey I saw, the Gallup poll, had only 16% of the people expressing approval of Congress. With regard to the Supreme Court, it has its lowest approval ratings in history. One poll that I saw had 30% approval, 59% disapproval. There's a Gallup poll that had only 25% expressing confidence in the government. We could say the same thing about surveys about confidence in state and local governments. And so I worry, how long can any government survive when it loses the confidence of the people? At the same time, our country is more politically polarized than it's been since Reconstruction. Again, there are measures of this. One measure is to look at a president's approval rating in his own party compared to his approval rating in the other political party. During Donald Trump's first term as president, he had 87% approval among those who identify as Republicans, 7% among those who identify as Democrats. There are other members of polarization as well. But by all of these measures, our country is deeply politically polarized. Again, one can ask, how long can a government, a democracy survive with the kind of polarization that we see in this country? I think that the November 2024 election was a reflection of this. I think that we saw the President Trump win with just under 50% of the vote, about a percentage point and a half more than Kamala Harris. But you look at the map of the country, you see the deep political polarization. If we would take any major issue, you see the deep political polarization. So the premise of my book is that no democracy lasts forever. Democracies are there until they're not. We all can identify countries in the world that were once democracies, but no longer really are democracies. I would certainly put countries like Hungary and Turkey in this category. So that leads to the second part of my remarks, which is really the first half of the book. What's caused the crisis with regard to democracy? As I said, here my thesis is that there were choices that were made in drafting the Constitution that were undesirable then. They were necessary in order to get approval in Philadelphia and among the states. But because of changes in society, in population, in partisanship, they become much more salient in recent years. Well, let me give you some examples of what I mean here. One is the Electoral College. The Electoral College was a terrible idea in 1787. It was based on distrust of the people. Alexander Hamilton in the Federalist Papers wrote that we shouldn't have the people selecting the president. It should be the informed elites. And that's part of why the Electoral College was created. The Electoral College also was created to enhance the political strength of states where there were enslaved people. In fact, this was seen at the time. The Electoral College allocates to each state a number of electors that's the sum of its senators and representatives. Before they took up the Electoral College or the method of choosing the president at the Constitutional Convention, they'd already decided that enslaved people would count as 3/5 of a person in allocating seats in the United States House of Representatives. When they chose to have the Electoral College, it meant that those states that had enslaved people would get political strength from them because they would count as 3/5 of a person in allocating seats in the House, which would then be part of seats in the Electoral College. This is not hindsight. At the Constitutional Convention, Hugh Williamson, a delegate from North Carolina, said exactly this. None other than James Madison, a delegate from Virginia, praised the Electoral College on this basis. The Electoral College didn't matter much in the 20th century. Never in the 20th century was the person who lost the popular vote chosen as president by the Electoral College. But twice in this century, in 2000 and in 2016, the loser of the popular vote became president because of the Electoral College. It also almost happened two other times. In 2004, if John Kerry had prevailed in Ohio, he would have won in the Electoral College despite losing the popular vote. In 2020, if Donald Trump had won about 42,000 more votes in 3 states, he would have elected president despite losing the popular vote by 7 million votes. Why in the 21st century is the Electoral College so much more of a problem than the 20th century? Well, population shifts and partisan realignment mean that the Electoral College is much more likely now to choose the loser of the popular vote than was true previously in American history. But let me point to another flaw, I think, from drafting the Constitution, and that was allocating equal representation to each state in the United States Senate. Again, to be sure, this was a compromise that was essential for getting a constitution accepted in Philadelphia and ratified by the states. The smaller states wanted equal representation in Congress. The larger states, understandably, wanted representation allocated by population. The solution was a compromise. A House of Representatives where representatives were allocated by population, a Senate where there was equal representation among the states. At the time the Constitution was written, the difference between the largest state and the smallest state in population was about 12-1. Now the difference between the largest state, California, and the smallest state, Wyoming, is 68-1. And yet they both get 2 senators. There's no way to reconcile that with the principle of one person, one vote. For any elected body with districts, all must be about the same in population. In fact, the Senate is the only elected body in the United States where there can be deviation from one person, one vote. No state legislature can replicate it. No city government can replicate it. Let me put it to you in another way. In the first 2 years of the Biden presidency, you might recall that there were 50 Democratic senators and 50 Republican senators. The 50 Democratic senators represented 42 million more people than the 50 Republican senators. A third flaw in drafting the Constitution, I think, was creating life tenure for Supreme Court justices and for federal court judges. At the time the Constitution was written, average life expectancy was 36 years. The framers couldn't imagine what we've seen in terms of justices staying on the bench truly for decades. Again, I can give you statistics about this. From 1787 until 1970, the average tenure of a Supreme Court justice was remarkably constant, 15 years. For justices who have been appointed since 1970, who have left the bench, their average tenure is 27 years. Think of Clarence Thomas. He was 43 when he was confirmed for the Supreme Court in 1991. If he stays on the bench until he's 90, the age was Justice John Paul Stevens retired, he will be a justice for 47 years. So this doesn't sound partisan. Elena Kagan was 50 when she was confirmed for the court. She remains till she's 90. She'll be there for 40 years. Amy Coney Barrett was 48 when she was confirmed for the Supreme Court in the year 2020. If she remains on the court until she's 87, the age Justice Ruth Bader Ginsburg died and left the bench, Barrett will be a justice until the year 2059. This is just too much power in a single person's hands for too long a period of time. Too much depends now on the accident of history when there's vacancies. Richard Nixon got to fill 4 seats in his first 2 years as president. Jimmy Carter got no vacancies to fill in his 4 years as president. So you know Donald Trump picked 3 justices during his first term as president. The prior 3 Democratic presidents, Jimmy Carter, Bill Clinton, Barack Obama, served a combined 20 years in the White House, but picked only 4 justices during that time. Another tragic flaw with regard to the Constitution was how it treated race. Alexis de Tocqueville, in his book Democracy in America, early in the 19th century, said that race was the fundamental flaw that the Constitution was based on. The Constitution very much protected the institution of slavery. Things like the 3/5 clause, the fugitive slave clause, the ban on Congress limiting importation of additional enslaved people. all protected the institution of slavery. Not once from 1787 till the Civil War did the Supreme Court chip away at the institution of slavery. It consistently protected the rights of owners of enslaved people. Finally, I think a real flaw in the Constitution is how difficult it is to change. The framers were afraid that they were making it too easy. Under the Articles of Confederation, it took unanimous consent of the states in order to amend the Constitution. The Constitution that they drafted in Article 5 says an amendment, at least this is the procedure that's always been used, takes 2/3 vote of both houses of Congress and 3/4 of the states. The Constitution is amended only 27 times since 1787. 10 of those were the Bill of Rights in 1791. So it means since 1791, there have only been 17 amendments, and 2 of those were to create and repeal prohibition. The problems that I've just spoken of are in the Constitution. I think that the problems have been exacerbated by some of the choices that are made along the way. With regard to choosing the president, all but 2 states, Maine and Nebraska, use winner-take-all in allocating electoral votes. If you voted for Donald Trump in California in 2024, or for Kamala Harris in Texas in 2024, it's as if you didn't vote at all. There's nothing in the Constitution about winner-take-all, but it makes it much more likely that the loser of the popular vote can win in the Electoral College. The Senate has created the filibuster over time, and it changed the rules in the 1970s to make it far easier to have a filibuster. For many of us, our image of the filibuster comes from Jimmy Stewart and Mr. Smith Goes to Washington, holding the podium in the Senate to protest corruption until he literally collapsed of exhaustion. Rarely are there filibusters like that anymore. We had one last month by Senator Cory Booker. Now there's the virtual filibuster. It just takes a senator indicating a desire to filibuster. No one has to hold the podium. The Senate goes on with its business. And until there's 60 votes, there's no opportunity for the Senate to act. This makes it much more difficult for the Senate to accomplish anything. The Supreme Court, I think, has made the situation worse with its decisions. I think Citizens United versus Federal Election Commission has done a great deal to undermine public confidence in the electoral system. It, of course, held that corporations can spend unlimited amounts of money to get candidates elected or defeated. It spread cynicism about our electoral system. The Supreme Court has invalidated key provisions of the Voting Rights Act. So it's all of these things together that I think have created the crisis of American democracy. Well, that leads to the third part of my remarks. How can this be fixed? I think it's so crucial to emphasize that every problem that I've identified can be fixed. Some of these can be fixed by statute. You don't need a constitutional amendment. Congress could do it, passing a bill signed by the president, or conceivably overriding a presidential veto. Let me give examples of this. With regard to the Electoral College, it can't be eliminated except by a constitutional amendment, but there can be a fix to winner take all. Congress by statute could require that all states allocate their electoral votes proportionate to the popular vote. According to statistics that have been generated, this would make it much less likely that the loser of the popular vote would win in the Electoral College. The Senate can reform its filibuster rules. It could say the first vote for cloture takes 60 votes, then 55, then a majority to prevent a filibuster from permanently blocking legislation. Legislation can overcome some of the Supreme Court's decisions that have been harmful. So, for example, Congress could adopt a law that revives the Voting Rights Act and addresses the Supreme Court's constitutional concerns. One of the problems that I think has created serious difficulties in American government is partisan gerrymandering. Partisan gerrymandering is where the political party that controls the legislature draws election districts to maximize their seats for that party. Partisan gerrymandering is nothing new. It takes its name from a governor of Massachusetts early in American history, Elbridge Gerry. He drew an election district that looked like a salamander, and a newspaper coined it gerrymandering, and the name has stuck. But what's changed is that because of sophisticated computer programs, because of detailed voter information, it's possible to engage in partisan gerrymandering with more precision than ever before. As Justice Elena Kagan said, this isn't your grandparents' partisan gerrymandering. So what you see is states like North Carolina that are essentially purple states, where Democrats and Republicans get almost exactly the same number of electoral votes. But because of partisan gerrymandering, Republicans win 10 of 14 seats. We see this in states like Pennsylvania, Ohio, and the like. Well, Congress can fix partisan gerrymandering for congressional races. Congress can say that every state has to have an independent commission to draw election districts for congressional seats and fix that problem. I think that it's possible by statute to overcome Citizens United, to decrease the corrosive effect of money in politics. So these are things that could all be done by statute without constitutional limit. I'm not confident that this Congress will do them, but I do believe it's possible for Congress to do these. There are things that could be changed by constitutional amendment. I recognize, as I said, how difficult it is to amend the Constitution. But let me give an example where I think a constitutional amendment is realistic and possible, and that's term limits for Supreme Court justices. I believe that there should be 18-year non-renewable terms for Supreme Court justices. 18-year terms would allow for the learning curve to succeed in the difficult role, but it would also allow for turnover. And if it was staggered, then ideally each president would get a nomination every 2 years, allowing every president to have equal influence over the Supreme Court. You might forget, but in 2016, 3 Republican candidates for the presidential nomination, Mike Huckabee, Ben Carson, and Rick Phillips, all argued for 18-year non-renewable terms for Supreme Court justices. According to opinion polls, over 3/4 of the people in the country would favor 18-year non-renewable terms for Supreme Court justices. So with bipartisan support possible, and with strong public support, a constitutional amendment becomes realistic. I think the only question is, who would be the constituency to do the hard work for term limits for Supreme Court justices? I think in order to be politically viable, they would have to be prospective. Republicans in Congress, Republican-controlled state legislatures aren't going to vote for term limits that apply to the current Republican majority on the Supreme Court. But I do think for the long term, a constitutional amendment for this is possible. And then in the longer term, we need to think about a new constitution. There's some things that can't be changed without a new constitution. The Electoral College isn't going to be eliminated by constitutional amendment. It could be, but the reality is that the small states that benefit with regard to the Electoral College aren't going to vote for a constitutional amendment to eliminate it. The 2 senators per state can't be changed by constitutional amendment at all. It's one of 2 provisions that Article 5 says can't be altered through the amendment process. My point with regard to a new constitution isn't that we should begin drafting it now. I think this particular moment would be very difficult for drafting a new constitution because our country is so deeply politically divided. On the other hand, there will be a point where there will be a new constitution for the United States. No constitution in any society lasts forever. And so what I suggest is we begin thinking about what would be the process we would want to use for a constitutional convention, knowing that one is likely a long way off. What happens if we don't do any of these things? Well, we will drift along. Maybe we'll just continue as we've been. Maybe we, like many former democracies, will drift into authoritarianism. Maybe there'll be the first secession movements that we've seen of any success or any serious nature since the Civil War. There's already an effort to get on the ballot in California for the next election, an advisory initiative on whether California should try to secede. I do not support secession. I do not believe that it is likely to happen anytime soon. But I do think that the more polarized we are as a country, the more people start questioning whether what unites us is greater than what divides us. And I have had a stunning number of conversations in the last couple of months of people in states like California, New York, Oregon, Washington, Illinois, wondering whether the ultimate path is secession. Opinion polls show a significant number of both Democratic and Republican voters think that secession may be on the horizon. Nothing else, looking at that abyss, what it would mean for the country and the world, might be an impetus for further change. Well, that leads me to the fourth and final part of my remarks. What's happened since January 20th, and how does that figure into this? I think that the events since January 20th are going to increase the crisis facing democracy. At the beginning of my remarks this morning, I said that the crisis facing democracy is about a loss of faith in government and political polarization. I think the effort to restructure, reduce the federal government is likely to further lessen confidence in it. If there aren't people in the Social Security office to process someone's Social Security benefits, there'll be further loss of faith. If people lose their Medicaid benefits, there'll be a further loss of faith. If we don't get accurate climate information, because the National Oceanographic Atmospheric Administration is being eliminated, there'll be a loss of faith. If students can't get their federally assured student loans, there'll be a loss of faith in government. And the more faith in government becomes eroded, the more there will be a crisis of democracy. At the same time, I think we would all agree that the actions of President Trump have been politically polarizing, supported among his followers, loathed among his detractors, but there's no doubt that he is not governing from the center or governing with any effort to unite. I am often asked, are we in a constitutional crisis? It's an interesting phrasing. There isn't phrase constitutional crisis in the Constitution itself. No law uses the phrase constitutional crisis. It's rhetorical. I also think that it wrongly implies something that's binary. We're in a constitutional crisis or we're not in a constitutional crisis. I think it's much more of a continuum. I would suggest we are in a constitutional crisis, though it could get much worse. We're in a constitutional crisis because of the flurry of executive orders that seem so clearly unconstitutional and illegal. President Trump, by executive order, has attempted to eliminate birthright citizenship, notwithstanding the first sentence of the 14th Amendment, that I think makes it clear that everyone born in the United States is a citizen, regardless of immigration status of their parents. The president has tried to eliminate federal agencies, even though they're created by federal statute, can only be eliminated by another federal law. The president has refused to spend federal money, even though the Impoundment Control Act makes clear the president has no authority to do that. The president has fired heads of agencies, notwithstanding a Supreme Court precedent upholding the ability of Congress to limit this. The president has even claimed that all civil service protections are unconstitutional. The president has targeted universities, in part because of their speech, and done so in a way that violates the Constitution and federal laws. The president has targeted law firms just out of retribution. The president has claimed the right to put individuals, even citizens, in a maximum security prison in El Salvador with no court having judicial recourse. This is just a handful of what's been done. So my sense is that these all do create a constitutional crisis. But the constitutional crisis can get worse. What if the president chooses to defy court orders? There's been some suggestion he might do this, and some indication that he's already doing this. Vice President J.D. Vance said the president doesn't have to follow court orders that involve the president's, quote, legitimate authority. President Trump has said, and I quote, that he who saves the country violates no law. There's indication that some of the court orders aren't being complied with. Some of the court orders to refuse spending aren't being complied with. Court order to bring back Kilmar Abrego Garcia hasn't been complied with. But we haven't seen declarations of open defiance. What if there is? What if President Trump says that the court has made its ruling, he's not going to comply with it? I think it's so important to recognize that never in history have presidents openly defied court orders. They've often complied even when they disagreed. President Roosevelt complied with the court orders striking down the New Deal, even though he vehemently disagreed with them. President Truman relinquished control of the steel mills after the court ruled against him. President Nixon released the White House tapes, even though it ended his presidency, even though he disagreed with it. President Eisenhower called out the troops in order to desegregate Little Rock public schools, even though he disagreed with the court's ruling. I know there's a famous quote attributed to President Andrew Jackson. John Marshall made his ruling, now let him enforce it. Andrew Jackson never said that. It wasn't attributed to him until 20 years after he died. In fact, the court case that was about, Worcester versus Georgia, involved a court order to the state of Georgia, not to Andrew Jackson at all. So what if President Trump defies court orders? What can they do? There's the power of criminal contempt. Individuals who defy court orders can be prosecuted for criminal contempt. But keep in mind, the president can pardon any who are convicted of criminal contempt. There's civil contempt. This fines a person or puts the individual in jail until the person complies with the court order. But it's always been that the United States Marshals enforce civil contempt, and they're part of the Justice Department. So what happens if the president defies court orders? What then of our constitutional system? After all, if the president can violate the Constitution and laws of the United States and defy court orders, the president can do anything. The president could put any of you or me in a maximum security prison in El Salvador, and when ordered to release us, could say, no, I'm not complying. Of course, the description, the word that's used for an official who literally can do anything without checks is a dictator. I am not saying that this is where we are. I'm saying that I'm worried about it. What I've realized since January 20th is how much our constitutional system depends on the good faith of those who are governing us. As I'm talking about now, it requires the good faith of those who govern us to comply with court orders. What we face now is the question of, will the guardrails of democracy hold? As we face this question, we should remember, no democracy lasts forever. So I've talked 30 minutes and glad to take your questions.
Well, thank you so much. And you gave me the permission to call you Erwin during this
Please.
conversation. So I want people to know that I'm not stepping over my bounds, but, one of our listeners was indicating that he thought this was a fascinating lecture and was hoping that you could offer a little bit of an analysis of how the Constitution touches our native nations. And is there a difference when citizenship is granted through an act of Congress versus a constitutional amendment? In the case of the Indian Citizenship Act of 1924, we had a webinar about that. We had a full seminar about that issue for a full day to celebrate the 100-year, commemorate the 100th year anniversary. But it was complicated at the time and still is complicated as you deal with the sovereignty questions. So give us your thoughts on that.
The treatment of Native Americans is, of course, one of the great tragedies of American history. With regard to citizenship, I mentioned to you the first sentence of Section 1 of the 14th Amendment. It says, all persons born or naturalized in the United States and within the jurisdiction thereof are citizens of the United States. In 1898, in a case United States versus Wong Kim Ark, the Supreme Court focused on the meaning of this sentence. And it said it wasn't meant to include Native Americans. Their citizenship was different because they're part of sovereign nations. And within the jurisdiction thereof wasn't meant to include if there's an invading foreign army and the children are born to them, or if there's a diplomat from a country and children are born to them in the United States, they don't become citizens. But everybody else becomes a citizen on birth or can become citizens by naturalization. For Native Americans, the statute that you describe, adopted in the 1920s, bestows citizenship upon them. And under the 14th Amendment, it doesn't matter whether somebody becomes a citizen by birth or a citizen by statute. All are United States citizens. And of course, now we simply accept that anyone born in the United States, whether Native American or otherwise, is a United States citizen.
And one of the other questions that our listeners are offering is, how do we deal with what might be called a constitutional crisis when the Supreme Court sets forth that the president is immune?
I think the Supreme Court's decision on July 1st, 2024, in Trump versus United States will be regarded as one of the worst in American history. I say to my students that I think there has to be a hall of shame for Supreme Court decisions that were tragically wrong. Dred Scott versus Sanford in 1857 that said that enslaved people are property, not citizens, even if born in the United States. Plessy versus Ferguson in 1896 that said that separate but equal was consistent with equal protection. Korematsu versus the United States in 1944 that upheld the evacuation of Japanese Americans during World War II. And I will put Trump versus the United States in that category. The very core of the rule of law is that no one, not even a president, is above the law. Yet Trump versus the United States says that if a president violates the law, even blatantly violates the law in an official act under the Constitution, there can be no criminal liability. Earlier, the court in Nixon versus Fitzgerald in 1982 said there can be no civil liability. So Donald Trump and every future president knows that even if they egregiously violate the law, there is no way to hold them civilly or criminally accountable. That just so seems at odds with the core of the rule of law. In her dissenting opinion, Justice Sonia Sotomayor gave examples. She said, imagine the president calls out the Navy SEALs to assassinate a political rival. Since it's the president's power as commander-in-chief, absolute immunity. Imagine that the president orders the Justice Department to prosecute for political retribution. Absolute immunity. Imagine the president takes bribes to issue pardons. Since the pardon power is under the Constitution, absolute immunity. And to me, this just seems so at odds with the rule of law. As I was saying in my conclusion, it enhances the fact that we depend on the good faith of those who govern us. We now have to depend on the good faith of those who are presidents not to violate the law, because no court can hold them accountable.
And when you look at this, often when we talk about the governmental, we have the government laws and the rules, but then we also have the norms. And the norms are unwritten. And one of the things, as you describe the constitutional crisis, it seems as if a big piece of the crisis is that the norms have been tested and pushed beyond what, those of us who are a little older, who, look and say, okay, we didn't anticipate that the norms would be challenged in this way. How would you address the differential concerns about what's actually in the law and what are the norms? How can we address those matters?
Norms are important in any context. There are norms for how I should behave in the classroom, for how my students should behave in the class. There are norms for how faculty members treat one another. These aren't written down, but they're so important in terms of behavior. There's norms of how we board buses or deal with people in lines in the supermarket. But there's also norms in terms of how government is supposed to operate. Let me give you an example so this is concrete rather than abstract. Until the year 2016, whenever there was a vacancy on the Supreme Court, the president nominated, the Senate deliberated, and it either voted to confirm or reject. And this included in election years. In 1956, a vacancy occurred in the Supreme Court just weeks before the November election. President Eisenhower nominated, the Senate confirmed. But when Antonin Scalia died in February of 2016, Senate Majority Leader Mitch McConnell, the day of Scalia's death, said, we're not going to hold hearings, we're not going to hold a vote. And so for the first time in history, the norm of the Senate considering and voting on a presidential nominee wasn't followed. Well, this is going to, I think, create a terrible precedent for the future. I predict for the foreseeable future, if the president and the Senate are of different political parties, the Senate just isn't going to confirm a presidential nominee for the Supreme Court. A crucial norm has broken down. And I want to emphasize that when I talked about what's occurred since January 20th, I'm not talking about the desirability of policies. I'm not talking about whether the tariffs are good or bad. I'm just talking about the Constitution. And on Sunday, May 4th, President Trump was asked on Meet the Press, do you have to follow the Constitution? And his stunning answer was, I'm not sure. Of course, he took an oath to uphold the Constitution on January 20th. But to me, that was an incredibly revealing, startling statement.
Now, if I were talking with someone, imagine that there's someone sitting in your chair who is talking about the Constitution in the context, who's a strong supporter of the president and the way he's going about, saying that we need to shake things up, it's time to move forward. How would you anticipate that person would answer the question of, is there a constitutional crisis underway?
One thing that's, I think, important is that many who identify as Republicans and even conservative Republicans are distressed by the violations of the constitutional laws of the United States. Let me take as an example. Senator Lisa Murkowski from Alaska said, she's very afraid, and those were her exact words, about what we've seen from the Trump administration. I also think it'd be important to separate where we might disagree over policy versus that which violates the Constitution and laws. Because I certainly can imagine those who defend President Trump supporting many of the policies that he's adopting. And I'm not going to, this program, talk about that because that's not what I'm here for. I'm here to talk about the Constitution. But I would hope that even those who support him would say, he has to follow the Constitution of the United States, that things that are clearly unconstitutional are beyond what the president can do. Let me take an example again. The president has no authority to eliminate a federal agency. Congress creates agencies. The federal government is then comprised of those agencies. Congress can eliminate the agencies, but the president doesn't have the authority to do that. There's no authority to put somebody in a maximum security prison in El Salvador and then say there's no opportunity for judicial review. That's not a close constitutional question. So I would hope if I was talking to somebody who's a strong Trump supporter, we would separate what are the policies and whether we agree to them versus what's unconstitutional. And I don't think even Trump's strongest supporters deny that some of what's being done is clearly unconstitutional.
And now I'm going to give you sort of for these last 10 minutes, I want you to think about this. There's been a lot of consternation over the past many years about whether we need a modern constitutional convention. And in fact, there was a time where state legislatures were calling for a constitutional convention around trying to have a balanced federal budget. And a number of states had called for the convention. There was a whole confab between state legislators and the governors because there was concern that we were very close to having the requisite number of states calling for a constitutional convention. And ultimately, it didn't move forward being called by the states. How would a modern constitutional convention look in your perspective? And how would that be called?
Someday there will be a constitutional convention. Someday there will be a new constitution drafted. Someday there will be a new constitution adopted. And I think we have to start with the premise how strange it is to be governed in 2025 by a document written in 1787. It was then a very small country all on the eastern seaboard. It was a society that was largely agrarian. It was in many states dependent on enslaved people, and now compare it to the modern world. In fact, the more the Supreme Court says that the meaning of the Constitution is limited to its thought in 1787, the more absurd it becomes to be governed by it. Congress, under the Constitution, can call a constitutional convention. In fact, the Constitution says in Article 5 that 2/3 of the states can call for a constitutional convention, and then Congress can convene one. In the book, No Democracy Lasts Forever, I suggest we shouldn't follow the Article 5 procedures for a constitutional convention. There is a precedent for not following the procedures in the Constitution for revising the Constitution. And that's that the Articles of Confederation were explicit that it would take unanimous approval of the states in order to change the Articles of Confederation. The Congress, under the Articles of Confederation, convened the convention in Philadelphia in 1787. It was to propose amendments to the Articles of Confederation. One of the early things they decided was to scrap the Articles of Confederation and propose a new constitution. And Article 7 of it says, it's the law if approved by 3/4 of the states. When George Washington was elected president, North Carolina and Rhode Island hadn't yet even approved the Constitution. Rhode Island didn't do so until a year into the George Washington presidency because of protest over the Constitution's provisions with regard to slavery. So I think we should begin considering what would be a constitutional convention that makes sense today. I don't think we should allocate representatives by states. In the end, I don't think it should be approved by the states, because if we do that, we're never going to change the Electoral College of 2 senators per state. I believe that what most countries do should be followed in the United States. The proposed new constitution should be put to the people for a vote.
Well, that certainly would be fascinating to see how that might move forward. If you were to, look ahead while looking behind at the same time, you're a constitutional scholar, so you've looked at what was done in 1787, how it's been revised over time or not revised. Imagine yourself in a conversation with the founding fathers, and yeah, they were all fathers. We know that. What do you think they would think would be the most surprising changes that have happened in this country?
I don't think they could have possibly imagined the world we live in today. I mean, a world with electricity, a world with airplanes, a world with the internet and social media. I think of my grandparents who were born in Eastern Europe around 1900 and the dramatic difference that they saw in their lifetime. Um, and you go back to 1787, it's incomprehensible. So if you ask me what they would be most surprised by, I think it's that the document that they drafted and ratified in 1787 is still being used in 2025.
And not only being used, but being used as a beacon across the world, as the set of countries striving for democracy. Still, with all the flaws that we have in this country, which there are plenty of them, we still set forth that we want to create a more perfect union, that under our laws, all are created equal. And that does seem to still provide a beacon across the world.
As well, it should. This country's been a constitutional democracy at least since 1787. That's the longest continual constitutional democracy in world history. But we shouldn't take it for granted, and we shouldn't let our reverence for the Constitution obscure our focus on its flaws. And we are facing a challenge to constitutional democracy, unlike what we've seen before. And we'll really see, as I said, whether the guardrails of democracy can hold.
That will be the question before us. And, we thank you very much, Erwin. I know, you've been with us before, and you're a prolific scholar, and we appreciate very much the fact that you've donated your time to be with us. One of our listeners asked, will this be posted on our website? Yes, indeed. This conversation will be on our YouTube channel, and all who are signed up will get a notice of the time when it's on, so you can share it with your friends and neighbors. And so we are happy to have you with us today. And we're now going to turn to looking forward to things that are coming up. So here we have our upcoming events. Coming up on Thursday, May 29th, Civil War in Statuary Hall. That is a look at the conversation that has gone on about what statues will be placed in Statuary Hall. The National Statuary Hall provisions allow each state to place 2 statues in Statuary Hall. There's a specific requirement that the person who is depicted in statue must be dead. And the interesting thing is, why do we raise that? North Carolina actually voted to put Billy Graham into Statuary Hall while he was still alive. And he was not eligible at that time, but he ultimately died and is now in Statuary Hall. So that conversation about how that happens and how it changes over time is going to be on Thursday, May 29th. And then we have Dr. Scott Spillman talking about America's long reckoning, the founding era to today, making sense of slavery on June 12th. That is in the run-up to Juneteenth, which is now a national holiday, the day in which the enslaved people in Washington, D.C. were emancipated. And then on June 26th, Charles Sumner is going to be highlighted with Charles Sumner, Conscience of a Nation, with Zakir Tamez. Now, most of the people who think about Charles Sumner just think about the fact that he was caned while serving in the United States Senate. And they may not know of the depth of his work and his engagement. He was a dedicated abolitionist who worked hard to try to bring equality to our nation. And then we go from Trenton to Yorktown with John Massis on July 3rd, part of our 4th of July story. So we will hope that you will join us for these interesting new webinars coming coming forward to us. And we thank you so very much for joining us today. As always, we thank you for your contributions, for your donations. Keep those cards and letters coming, because we are chartered by Congress to tell the history of the Capitol and the people who've worked in it, but we are funded by the people who support us, who believe in public history and civics. Thank you so much for being with us. Thank you, Erwin. Thank you, Sam. Thank you, Vincent. We appreciate your work. We look forward to seeing you again soon. Be well. Goodbye.